Bradley.
Good morning, Your Honor.
Good morning. Can you turn your video on, please?
Yes, sir. Can you see me, Judge?
I can. Are you here on the Cadence Bank versus Keith Moore case?
Yes, Your Honor. I represent Cadence Bank.
Okay. If I could have my bailiff just verify that the named defendant Keith Moore is not in the hallway or in the courtroom. Sarah, can you verify Jacob heard me?
There's nobody in the hall or in the courtroom.
All right, proceed with your quick prove up, Mr. Bradley.
Yes, Your Honor. My name's Rick Bradley, and I represent Cadence Bank. We're here on a breach of contract action. Defendant car scientist entered into a credit card agreement with Cadence Bank. This agreement was secured by a personal guarantee agreement executed by Keith Orr. This personal guarantee agreement provided that Keith Orr would personally and unconditionally guarantee the contract. The car scientist and Keith Orr have charged more than $42,000 on this account. I believe it's $42,896.79. They have refused to pay on the account. Demand was made. They still refuse to pay. We filed a lawsuit alleging breach of contract, among other causes of action. And now we have moved for a traditional motion for summary judgment on our cause of action, as well as a no evidence motion for summary judgment on various affirmative defenses that the defendant raised. Defendant has not responded to our motion for summary judgment. But within our summary judgment, we have attached not only the credit card agreement, but also the personal guarantee agreement showing that defendants are liable for this amount. We also have an affidavit executed by Holly Brassel, who is our credit card manager, credit card account manager, who has described the default, the accounts, as well as the amount due and owing. And we also attached affidavits in support of attorney's fees that are authorized under both the agreement and Chapter 38 of the Texas Civil Practice and Remedies Code. So at this time, we would respectfully move for summary judgment and an award of attorney's fees in favor of Cadence Bank.
All right, motion for summary judgment is granted in the amount of $42,896.79 plus attorney's fees in the amount of $1,592.38 with post-judgment interest at a rate of 5% per year on the total judgment amount of $44,489.17.
Thank you, Your Honor.
Anything further, Mr. Bradley?
No, Your Honor.
Have a good day.
Thanks, you too. May I be excused?
You may.
Morning, Your Honor.
Morning. Can everybody hear me?
Yes, sir.
Yes, sir.
Okay. We're on the record in 24 CCV 074702, Pawnee Leasing Corporation versus Sparks and Stone Logistics LLC, Eric Stone and Colin C. Sparks. All right, we're here on a motion for summary judgment. Actually, there's two motions for summary judgments now filed, one for plaintiff and one for defendant. Trying to see if both were noticed for today's hearing.
I have not seen defendant's motion for summary judgment that I'm aware of. I've seen a response.
I'm sorry, Counselor, you are correct. My mistake. I'm thinking of another case that I reviewed. Yes, we're just here on your motion for summary judgment. That is correct.
Okay. There was a head that was going to roll.
All right, Counselor, it's your motion. Why don't you get us started?
Thank you, Your Honor. On September 16 of 2021, an entity named Tandem Finance, Inc. entered into an equipment finance agreement with the defendant Spark and Stone Logistics LLC. And at the same time, Mr. Stone and Mr. Sparks executed a guarantee of that agreement. That document has been attached to plaintiff's lawsuit, and it's also been attached to the motion for summary judgment as Exhibit A, and it's been supported by the affidavit of plaintiff's representative. Contemporaneous with the execution, it was thereafter assigned directly to the plaintiff. There's no evidence of it, and the court doesn't have to consider, but basically Tandem is a broker. They brokered the deal, and then it was all assigned to plaintiff at the same date in September of 2021. For 2 years, payments were made, and then payments stopped, and the equipment was recovered and sold in a commercially reasonable manner. And after that sale, there was a balance due of $24,982.20. There is a payoff quotation that is attached to both the lawsuit and to the summary judgment motion, confirming that document is the statement of account for the balance that is due. Plaintiff therefore has presented evidence of a contract, and then there's the breach, and then there's the balance that's due. And that's what we're asking for. I've reviewed the defendant's pleadings and their response. They have pled, number one, that there's a plea to the jurisdiction because this court has no jurisdiction. They cited a line out of the equipment finance agreement, but for some reason left off the balance of the sentence. They cited to the fact, and they on page 3 of the equipment finance agreement, it says that you agree that legal action may only be brought in the state or federal courts in Larimer County, Colorado. And then they had a period there. They left off, except that we may file any action where the equipment is or has been located at any time. That's in the state of Texas. That is in Fort Bend County. So it was a little disingenuous to state that the court has no jurisdiction. Then they say they complain about the genuineness of the endorsement, basically raise an affirmative defense. Well, at that point in time, the burden shifts to the defendants, and the defendants are now required to present evidence that supports their affirmative defenses. And there's been nothing that's been presented in the response to the summary judgment. There's no affidavits. There's no depositions, interrogatories, admissions, or stipulations. No evidence presented at all. So what the court has before it is plaintiff's presentation of a contract that has been breached and what the damages are, and nothing except for pleadings without proof to contradict. We're asking for summary judgment to be granted in the amount pled for of $24,982.20 plus interest, court costs, and then we've also presented an affidavit for legal fees, which once again has not been contradicted.
Thank you, Counselor. Mr. Sparks.
Good morning, Your Honor.
Good morning.
The lawsuit filed by plaintiff doesn't give any indication of where venue should be and how the court has jurisdiction. The contract calls for the jurisdiction to be in Laramie County, Colorado, and the state or federal courts. The fact that plaintiff didn't try to exercise or alert the court or even the defendants to where or how this court has jurisdiction gives us the ability to raise a fact issue in terms of the court's inability per the contract to exercise to exercise subject matter jurisdiction on the matter. They allege that, or counsel argues that in the contract on page 3 that we left out, and it could be anywhere the contract is held, but they don't indicate to what degree they have factual basis to establish that the vehicle was ever in Fort Bend County, ever in the state of Texas. This is a truck that was taken over the road, out of state, various states, and nothing is in the pleadings to indicate that it was in the state of Texas or Fort Bend County. Their contract specifically states it shall be in Laramie County, Colorado. Now, summary judgment, we've got to allege and raise tribal issues of fact. And these are tribal issues of fact of whether or not there's a subject matter jurisdiction issue, and there's affidavits for the defendants that the signatures allegedly related to them aren't genuine. This is a summary judgment that's brought 3 months after a lawsuit. No discovery has been done. Nothing to indicate that the persons even sued are the persons that are fixed to the contract.
Continue.
I support that we've raised significant factual issues that would deny their motion for summary judgment. Now, if there's other information that they want to bring forth to establish jurisdiction, then certainly the law might allow that. But on a motion for summary judgment, the pleadings and nothing that's been brought before the court to date denies that.
Okay. Thank you, Mr. Sparks. Mr. Scheinthal.
I have nothing further to add, Your Honor.
No rebuttal.
No, sir.
I'm denying the motion for summary judgment. Do we have this set for trial, Sarah? Yes.
Yes, sir, it's set for a bench trial on January 28th.
Very good.
Your
Okay.
Honor, may I ask, is it procedural? I mean, is it jurisdictional that the court is denying this? Because or is it something else? I mean, I'm not asking you to explain your ruling other than if it's jurisdictional, then that's something that's different than factual.
I'm denying the motion. Thank you, Counselor.
Okay.
All
Thank
right.
you, Your Honor.
Thank you, Judge. May we excuse?
Yes, you may. Y'all may. Bench trial is set for January 28th, 2025 at 9 a.m. Just as a reminder, everybody should have a copy of the uniform scheduling order.
Okay.
Have
Thank
a
you.
good day.
Thank you, Judge.